If you recently received a denial on your immigration case, you might be wondering if you should file an I-290B appeal or if you should just refile your case. Hi, I'm attorney Megan Pastrana of Immigration for Couples, and my firm is dedicated exclusively to helping couples across the nation and across the world in navigating the U.S. immigration process. The decision about what to do or what are your next steps if your case is denied is really going to be dependent upon your case type and the reason why your case was denied. So, in the world of immigration, if you have filed your immigration case and there's something that's missing in your case, typically immigration will send you a request for evidence. Sometimes they send a notice of intent to deny. And if you don't properly comply with those requests, or if you don't meet the eligibility requirements and immigration ultimately decides to deny your case, that decision is final. But in that denial notice, at the very end, they always put there's an option to file an appeal or an I-290B motion to reconsider or reopen your case. And so that decision about whether or not to move forward with that I-290B is going to be largely dependent on your case type and the reason for the denial. If it is because you didn't provide all of the documents and the request for evidence, it's not going to make sense for you to move forward with appealing your case or asking for the case to be reopened. Because when you're filing this I-290B, you have to show either that immigration made a mistake and how they applied the law to your case, or that there was evidence that wasn't available at the time of the request. And so it can be a very delicate and very difficult decision to decide whether or not to move forward with filing the I-290B. And in many cases, it makes more sense to refile your case and make sure that the refiling of the application is done accurately that second time around. But the decision is really going to be very case specific, and it's very important to speak with an immigration attorney. So there are times where I have met with couples and I say, absolutely, immigration made a mistake here. They misapplied the law, or they really shouldn't have requested this document, or what you sent was accurate. And we should go ahead and move forward with filing this I-290B immediately because you do have a 30-day filing deadline. And in other situations, couples have come to me, they've done their own case, they didn't understand the rules, they made a mistake. And ultimately I say, I hate to be the bearer of bad news, but filing the I-290B is going to result in the same decision and you're going to lose time, and it makes sense to just refile. So again, it's going to be largely dependent on your specific situation, but definitely speak with an immigration attorney immediately upon receiving that notice of denial so you can make a strategy moving forward. I invite you to check out my free resource center at immigrationforcouples.com. Thanks for watching.